So we had started with the good faith exception that was developed by the Supreme Court in 1984 in the U.S. versus Leon case. Remember kind of how I described this to you last time? We go from the 1960s down to the mid-1980s, and it's pretty clear what the trend of the decision, the overall trend of the decision of the court is, what the emphasis is. It is to be more protective of the rights of the accused, okay? But then 1984 marks a clear turning point. By this time, you have a majority of the court, which is either Nixon or Reagan nominees, right? And there begins to be a pretty noticeable conservative tilt in the court's decisions. And the first of these came in U.S. versus Leon. Now, I reported that to you a little bit inaccurately last time. So, as again, it was something I was thinking a little bit about after the class session was over. So I decided to go out and dig up a extended explanation of this case. I like this particular explanation of the case because it is from a book by my former colleague, John Domino, who I used to have an office right next to when I was at Sam Houston State University many years ago. And we used to kind of sit around and talk about these cases. In this case in particular, I remember because it was one that he was researching for his book. Okay. And here's his description of this case. Right? Although the Burger Court, by the way, whenever you see a name, whatever the name is, court, it's referring to who is the Chief Justice at the time, right? So this would have been when the Chief Justice was Warren Burger. Okay, that would have been, he was a Nixon appointee, so it would have been in the 1970s, okay? From the 1970s, beginning in the 1970s, okay? So although the Burger Court left the exclusionary rule developed in map standing, it legitimized a number of important exceptions. The most important of these came in the United States versus Leon. Proceeding on an anonymous tip of unproved reliability, police officers began an investigation into Alberto Leon's alleged drug trafficking. A search warrant was issued after several deputy district attorneys reviewed an affidavit summarizing the officer's surveillance. The searchers turned up large quantities of narcotics and drug paraphernalia. After Leon and co-defendants were indicted on federal drug charges, a federal judge granted a motion to suppress evidence on the grounds that the affidavit was insufficient to establish probable cause. Do you understand that point right there? So when the police go to a judge and ask for a search warrant, they have to establish probable cause, which means what? In other words, the judge is supposed to be skeptical, right? The judge is certainly not supposed to be a rubber stamp for the police and just give them search warrants whenever they ask for them, because the judge presumably is also there to protect the rights of the accused, right? So when the police go to ask for a search warrant, they're supposed to be able to say with a high degree of probability that what they're looking for, they're actually going to find, okay, where they say they're going to find it. And if that is not supported, then the judge is not supposed to issue the warrant. So what really happened in this case is, they fill out the affidavit, they swear out the affidavit, and the judge signs off on it, issues the warrant. But in hindsight, the presiding judge at trial said, well, that information, that affidavit really was not sufficient to establish probable cause, so the search warrant should not have been issued.
Does that mean
okay?
That they can be tried for what they did?
I'm sorry?
Then they could be tried for what they
Well, it's not that they can't be tried. Remember, that was an issue that we kind of took up after when we were watching that program. It's not that they can't be tried, it's that the state, the government, can't use the evidence that they obtained from the search. If they have other evidence, maybe they have eyewitness testimony, maybe they have some other kind of evidence that they want to go forward with trial, they just can't use this evidence, right? In any fruits of the poisonous tree that might also come about, right? So, in other words, the trial judge is saying that the magistrate who signed off on this warrant should have never signed off on this warrant, okay? However, the Supreme Court is saying on this appeal, Leon's lawyers are arguing that because the evidence should not have been introduced at trial, if not for that evidence being introduced at trial, my client would not have been convicted. Therefore, his conviction should be reversed and he should be released from custody. Okay? But the Supreme Court of the United States denies that appeal, saying that it's not the police officer's fault that the judge made a mistake. They were serving that warrant in good faith. And so we're not going to punish the police because of a mistake made by the judge. And I suspect that the defense lawyers might argue, no, you're going to punish my client for a mistake made by the judge, right? But that's neither here nor there, right? I mean, obviously you would expect the defense attorneys to take a different view of that.
So that's been fixed, right?
What's been fixed?
Not fixed, but like say if that happens right now, like if they had a faulty warrant, they found stuff, they ended up trying you, like, so.
To my knowledge, if I understand your question, if a judge was to make a similar mistake in 2021, this was 1984, very similar circumstances, whatever the facts, let's just take these facts that are presented here and say they happened in 2021, the judge makes the same mistake that the judge made back in 1984, that law still, that case law that the court developed in Leon is still the prevailing law. They would say, no, it was a good faith exception to the exclusionary rule, that the police were not flouting the Fourth Amendment, the police were not, disregarding the defendant's rights. They believed that they were serving a valid search warrant.
Yeah.
Now, we hope that there aren't too many judges out there that make those kinds of mistakes, but they're human beings as well, right? And so they're bound to make mistakes from time to time. Okay? All right, questions about that? Notice, though, that Byron White, who wrote the opinion for the court, ruled that the exclusionary rule should be modified to allow the use of evidence obtained by police officers acting in good faith on a search warrant issued by a neutral magistrate, even though the warrant is ultimately to be unsupported by probable cause. White reasoned that since the Fourth Amendment contains no specific provision precluding the use of evidence at a defendant's trial, the exclusionary rule is not set in stone, but is purely a creation of the court. Thus, Leon established a good faith exception to the exclusionary rule. But as Justice White pointed out, there are limits to the good faith exception. The officers reliant on the magistrate's probable cause determination and on the technical sufficiency of the warrant he issues must be objectively reasonable. Right? Further, if the magistrate who issued the warrant was intentionally misled by the officer, that's a different matter. The fruits of the search may be suppressed. And the good faith exception does not apply in cases where the magistrate acts as a rubber stamp or where the warrant is not based on probable cause or fails to specify the place to be searched and the items to be seized. And so presumably if Mapp versus Ohio were decided in 2021, if the police got a search warrant specifying that they were looking for evidence in a bombing case, and they went to Mrs. Mapp's residence and they conducted their search and they didn't find any evidence in the bombing case, but they did find pornographic materials, and they decided to prosecute her under local decency laws or indecency laws, whichever is appropriate there. Presumably the court would hold the same way that it did in 1961, that doesn't constitute a good faith exception because the warrant itself specified that they were looking for evidence in a bombing case and not in decency, matters of decency.